Hi, it's Roland Jones. Just another short video on preference on fraudulent conveyance issues. This is a case coming out of Puerto Rico, a Puerto Rican bankruptcy court, and it's an appeal to the bankruptcy appellate panel for the First Circuit. It's a recent case, 2016. In this case, the debtor was a tenant in a shopping mall, strip mall, and the defendant was the owner of the premises that was paid rent by the debtor. The amount is relatively small, $21,000. Bankruptcy court granted summary judgment for the defendant. The trustee appealed. The bankruptcy appellate panel reviewed the record, and basically the argument of the defendant in bankruptcy court was that the debtor paid late and always paid late, or regularly paid late, and paid late again in the preference period, and without further analysis, that was sufficient to prove an ordinary course defense. The defendant basically moved for summary judgment and attached as an exhibit a ledger without any other arguments. The trustee and the bankruptcy court granted summary judgment. The bankruptcy court said appears that there was a flexible attitude by the defendant in accepting late payments, and that was sufficient to render the payments ordinary. On appeal, the trustee argued that this is insufficient to prove ordinary course, and that there was no successful argument with respect to the industry standard. So, the main issue in front of the panel was did the bankruptcy court properly grant summary judgment to the defendant, and was this sufficiently based on sufficient evidence of ordinariness? This is the applicable section 547C, the defense based on 547C2A. But the issue is also, as raised by the bankruptcy appellate panel, who has the burden of proof in the defense, and it is the defendant that has the burden of proof. The defendant has the burden of proving the ordinary course defense. And that became an issue in the appellate court's consideration of this appeal. What obviously was a rather annoyed bankruptcy appellate panel found that the bankruptcy court erred, and that defendant, by simply attaching a ledger and without providing any analysis at all, there was no comparison of averages, there was no assertion or analysis of what the appropriate look-back period, or I'm sorry, what the appropriate base period was. There was no analysis of the range of payments outstanding between the two periods. And there was simply an assertion that this was ordinary because late payments were regularly accepted. This flew in bankruptcy court, but obviously did not fly in appeal. The appellate panel found that the bankruptcy court erred and vacated the order granting summary judgment, basically saying the basic holding, I guess, here is that simply providing a ledger or some data is insufficient to meet the burden of showing ordinary course. There's got to be some analysis. There's got to be a comparison. There's got to be something more than just submitting a ledger and then accompanied by a statement saying, hey, they usually accepted late payments and that's sufficient. There's got to be more, as this court put it, quoting another court, there's got to be more finely grained presentation of the defense. And so the court basically said it's just not enough. The defendant just didn't meet its burden because it didn't supply any analysis. Anyway, the takeaway here is you got to provide some analysis. I don't think this is earth-shattering news to most defense lawyers, but if it's news for you and you're representing defendants in preference cases, then don't just attach a ledger or some data. You've got to present an analysis.